I never thought my heating and cooling business would land me in a 3-year legal battle with the most vindictive homeowners association in Phoenix, Arizona. But that's exactly what happened when Patricia Hutchinson decided she didn't like the sight of my work van in my own driveway. My name is Ryan Zimmerman, and I'd been running Desert Heat Solutions from my home office in the Sunset Ridge community for 8 years without a single complaint. I had all the proper business licenses, insurance, and permits. My operation was completely legitimate. I kept my tools and equipment neatly organized in my garage, and I only parked my van in the driveway overnight like any normal person would park their vehicle. The van was clean, professionally wrapped with my company logo, and definitely not an eyesore by any reasonable standard. But reasonable wasn't in Patricia's vocabulary. It started on a Tuesday morning in March 2023. I was loading my van for a service call when I heard the clicking of heels on pavement behind me. I turned to see Patricia approaching, clipboard in hand like she was preparing to cite me for war crimes. "Ryan Zimmerman," she said, her voice sharp enough to cut glass. "We need to discuss your flagrant violation of our community covenant." I set down my tool bag and wiped my hands on my jeans. "Good morning to you too, Patricia. What violation are you talking about?" She thrust the clipboard toward me, pointing at some highlighted text with a perfectly manicured nail. Section 7, subsection C clearly states that no commercial vehicles are permitted to be parked overnight in resident driveways or on community streets. I'd read the HOA covenant when I bought the house in 2015. That section refers to semi-trucks, delivery vehicles, and equipment trailers. My van is a standard Ford Transit. It's not a commercial vehicle in the context of that rule. Her face flushed red. "It has your business name plastered all over it. That makes it commercial. By that logic, anyone with a company car would be in violation. The rule was designed to prevent actual commercial vehicles like 18-wheelers from being parked here. My van weighs under 10,000 pounds and fits comfortably in a standard parking space." Patricia's lips pursed so tightly they almost disappeared. "The HOA board will be reviewing this matter. You'll receive official notification within 5 business days." She spun on her heel and marched back toward her house 3 doors down. I should have taken that threat more seriously. True to her word, I received a certified letter the following Monday. The HOA board, which consisted of Patricia as president, her best friend Deborah Manning as vice president, and 3 other residents who apparently couldn't say no to Patricia, had determined that my van violated community standards. I was ordered to remove it from the property within 30 days or face daily fines of $100. I called an emergency meeting with the board. They agreed to see me that Thursday evening at the community center, a small building near the neighborhood entrance that hosted everything from yoga classes to book clubs. When I arrived, all 5 board members sat behind a folding table like they were the Supreme Court. Patricia sat in the middle, looking smug. Deborah was to her right, nervously shuffling papers. The other 3 members, whose names I learned were Frank Delgado, Susan Thornton, and Michael Porter, looked uncomfortable. "Thank you for coming, Ryan," Patricia said in a tone that suggested she wasn't thankful at all. "We've reviewed your request to appeal our decision, and we're prepared to hear your argument." I stood before them feeling absurd. I've been parking my van here for 8 years without issue. The covenant section you're citing doesn't apply to standard work vehicles. I'm a licensed contractor serving this community and many others. Many of our neighbors have used my services. Frank cleared his throat. "I actually have used Ryan's services. He fixed my air conditioning last summer." "Did a great job." Patricia shot him a look that could freeze lava. That's not relevant to the discussion, Frank. The issue is the commercial vehicle. But it's not a commercial vehicle under the legal definition, I protested. I checked with the Arizona Department of Transportation. A commercial vehicle is defined as one used to transport goods for commercial purposes exceeding certain weight limits, or vehicles designed to transport 16 or more passengers. My van doesn't meet any of those criteria. Susan raised her hand timidly. Patricia, maybe we should have the community attorney review this before we proceed. We already have, Patricia snapped. The attorney confirmed that the board has broad discretion to interpret and enforce covenant provisions as we see fit. That should have been my first warning sign. When an HOA says they have broad discretion, they usually mean they plan to do whatever they want regardless of what's actually written in the rules. Can I see that legal opinion? I asked. Patricia's eyes narrowed. That's privileged board correspondence. I'm a homeowner in this community. I have a right to review documents that directly affect my property rights. You have no such right, Deborah chimed in, finally finding her voice. The board operates independently to serve the community's best interests. Michael Porter, who'd been silent until now, leaned forward. Look, Ryan, maybe you could just park the van elsewhere. Rent a storage space or park it at a business location. That would solve this whole problem. Why should I have to spend money to solve a problem that isn't actually a problem? I'm not violating any legitimate rule. This is selective enforcement and overreach. Patricia stood up, signaling the meeting was over. The board's decision stands. You have 26 days remaining to remove the vehicle. This meeting is adjourned. I left feeling angry and bewildered. How had my quiet, normal business practice suddenly become a crisis requiring board intervention? Over the next few weeks, I did my homework. I researched Arizona HOA law, which is governed primarily by Arizona Revised Statutes Title 33, Chapter 16. I learned that while HOAs do have enforcement powers, they can't act arbitrarily or discriminatorily. They have to follow their own governing documents and apply rules consistently. I also discovered something interesting. Patricia herself had a home-based business. She sold essential oils and supplements through a multi-level marketing company. She regularly hosted parties at her house where she pitched products to neighbors. And she had a custom license plate on her luxury SUV that read Boss Babe, with her company's logo on a frame around it. If my work van was a commercial vehicle, surely her rolling advertisement was too. I documented everything with photographs and dates. I also surveyed the neighborhood and found at least 6 other residents who ran businesses from home or had vehicles with company logos. There was a real estate agent with her face and phone number on her car door. A plumber 2 streets over with a truck bearing his company name. A freelance photographer with a magnetic sign on his sedan. None of them had received violation notices. With this evidence in hand, I requested another hearing. Patricia denied it. I then submitted a formal written appeal per the covenant procedures. Patricia acknowledged receipt but provided no response within the required time frame. The 30 days expired. The next day, I received another certified letter informing me that I was being fined $100 per day until the violation was cured. The letter also stated that the HOA placed a lien on my property for the accumulated fines. That's when I hired an attorney. Jennifer Carlson was a property rights attorney in Scottsdale who specialized in HOA disputes. She had a reputation for not backing down from overzealous boards. When I met with her and showed her my documentation, she actually laughed. "This is the most clear-cut case of selective enforcement I've seen in years," she said, spreading my photos across her desk. They don't have a leg to stand on. So what do we do? I asked. First, we send them a demand letter citing the specific violations of Arizona law. We point out the selective enforcement, the failure to respond to your appeal, and the improper lien. We give them 10 days to rescind everything and confirm in writing that you can park your van without restriction. And if they don't, she smiled, then we sue them and we win. Jennifer drafted a comprehensive demand letter that was basically a preview of how badly they'd lose in court. It cited case law, statutes, and the HOA's own covenant provisions they'd violated. It documented the selective enforcement with photos and dates. It pointed out that their attorney's opinion about broad discretion was legally meaningless when that discretion was exercised in a discriminatory manner. The letter concluded with a demand for complete reversal of all actions taken against me, removal of the lien, and written confirmation that my van was permitted. It also requested that the HOA reimburse me for my attorney's fees incurred to date, which were already approaching $5,000. Patricia's response came exactly 10 days later. It was brief and dismissive. The board stood by its decision. The fines would continue to accumulate. The matter was closed. Well, Jennifer said when I forwarded her the email, they want to do this the hard way. Let's file suit. She prepared a complaint for the Maricopa County Superior Court asserting multiple claims: breach of the HOA covenant, violation of Arizona's HOA statutes, selective enforcement, denial of due process, and wrongful lien. We also sought declaratory judgment that my van was not a commercial vehicle under the covenant, injunctive relief, requiring removal of the lien and cessation of fines, and recovery of all attorney's fees and costs. That last part was important. Arizona law allows prevailing parties in HOA disputes to recover their attorney's fees. If we won, the HOA would have to pay Jennifer's bills. We filed the lawsuit in September 2023. By then, the fines had accumulated to over $18,000, even though I'd continued parking my van in my driveway every single night. I wasn't about to let them bully me into compliance with an illegal rule. The HOA hired a large law firm from downtown Phoenix to defend them. Apparently, Patricia convinced the board that they'd win easily. That law firm billed at rates far higher than Jennifer's. This was going to get expensive for someone. The discovery phase was fascinating. Through written interrogatories and document requests, we learned that Patricia had personally initiated the action against me after I'd refused to hire her son Brandon to work for my company. Brandon had applied for a technician position the previous December. He had no HVAC experience, no relevant education, and expected a salary far above what I paid experienced technicians. I'd politely declined to hire him. Apparently, Patricia took that personally. We also discovered that the board never actually consulted an attorney before sending me the first violation notice. Patricia had lied about that. The only legal consultation came after I'd challenged them, and even then, the attorney had cautioned the board about selective enforcement issues. Patricia had simply ignored that advice. During Patricia's deposition, Jennifer methodically destroyed her credibility. Patricia couldn't explain why my van was a commercial vehicle, but the real estate agent's car wasn't. She couldn't explain why she'd never disclosed that her son's job application was a factor. She couldn't produce any board meeting minutes showing that the board had voted on my specific case as required by the covenant. Most damaging, when confronted with photos of her Boss Babe license plate and company logo frame, Patricia actually said, "That's different. I'm not running a business. I'm an independent consultant." Jennifer didn't even look up from her notes. You sell products for profit, correct? Yes. You receive compensation for those sales? Yes. You recruit other sellers and receive compensation from their sales. That's how the business model works, yes. But you're not running a business, Patricia's attorney objected, but the damage was done. The transcript would speak for itself. We also deposed the other board members. Frank, Susan, and Michael all admitted they'd had reservations about the action against me, but had deferred to Patricia's judgment. Deborah admitted she'd never actually read the covenant section in question before voting to fine me. By March 2024, the HOA's legal bills had exceeded $70,000. Jennifer estimated they'd hit $100,000 before trial. Meanwhile, her bills to me were around $30,000, which I was paying from my business savings. The HOA made a settlement offer. They dropped the fines and removed the lien if I agreed to park my van elsewhere and pay my own attorney's fees. Absolutely not, I told Jennifer. We're going to trial. That's what I was hoping you'd say, she replied. The trial was scheduled for August 2024. In the months leading up to it, something interesting happened in the neighborhood. Other homeowners started coming forward with their own stories of Patricia's overreach. She'd fined one family for having a vegetable garden that she deemed unsightly, even though the covenant explicitly allowed gardens. She tried to force another family to remove a basketball hoop that was fully compliant with the rules. She denied a request for a reasonable accommodation under fair housing laws for a disabled veteran who needed a wheelchair ramp. A group of homeowners approached me about organizing a recall election to remove Patricia and Deborah from the board. I stayed out of it to avoid any appearance of retaliation during the lawsuit, but I certainly didn't discourage them. The trial lasted 4 days. Jennifer presented our evidence methodically. She called me as a witness to explain my business, my history in the neighborhood, and the complete legitimacy of my operations. She called an expert witness, a professor of property law from Arizona State University, who testified that the HOA's interpretation of the covenant was legally unreasonable and unsupported by the plain language of the document. She presented all the photos of other vehicles and home businesses that had never been cited. She presented the deposition transcripts showing the board's dysfunction and Patricia's vendetta. She presented the timeline showing that this only started after I didn't hire Patricia's son. The HOA's attorney tried to argue that the board had discretion to interpret rules as needed to maintain community standards. Jennifer countered that discretion must be exercised reasonably and consistently, which the board had failed to do. The HOA's attorney tried to argue that my van was more visible and prominent than other vehicles. Jennifer presented photos showing that wasn't true. Most tellingly, the HOA's attorney never put Patricia on the stand. After her disastrous deposition, they clearly didn't want her in front of the judge. Judge Robert Mendoza heard the case without a jury, as is typical for HOA disputes. He was a veteran judge known for being no-nonsense and fact-focused. Throughout the trial, I watched him take extensive notes and occasionally ask pointed questions. When he asked the HOA's attorney to explain why Patricia's vehicle wasn't considered commercial under their interpretation, the attorney stumbled through a non-answer that basically amounted to, because the board didn't think it was. Judge Mendoza's expression told me everything I needed to know. Closing arguments happened on the 4th day. Jennifer argued that this was a straightforward case of an HOA board abusing its power for personal reasons, violating its own rules, and attempting to impose financial punishment on a homeowner who had done nothing wrong. She asked for complete relief. a declaration that my van was permitted, removal of all fines and the lien, an injunction preventing future enforcement and full recovery of attorney's fees. The HOA's attorney argued that the board was acting in good faith to preserve property values and community character, and that any inconsistencies in enforcement were minor and didn't change the basic validity of their action. Judge Mendoza said he'd issue a written decision within 30 days. Those were a long 30 days. My business continued to thrive despite the distraction of the lawsuit. Ironically, all the neighborhood drama had actually gotten me more business as people heard my story and wanted to support me. I'd hired 2 additional technicians and bought a second van to keep up with demand. The recall election happened in September. Patricia and Deborah were both removed from the board in a landslide vote. Frank Delgado became the new president. He approached me at my house one evening. "Ryan, I want you to know that I'm sorry," he said. "I should have pushed back harder against Patricia. I knew what she was doing was wrong, but I didn't want the confrontation." "I appreciate that, Frank. For what it's worth, I don't blame you or the other board members who went along with her. Patricia can be pretty intimidating." "That's no excuse. We had a responsibility to all homeowners, not just to keep Patricia happy. If you win this lawsuit, the legal fees are going to come out of everyone's HOA dues. We've already had to levy a special assessment to cover what we've spent so far." That gave me pause. I hadn't thought much about the impact on my neighbors. "That's not my fault, Frank. I didn't ask for this fight." "I know, and everyone knows that. At the last meeting, we voted to authorize settlement discussions if you're willing. We'd like to make this right without spending more money on attorneys. I'll talk to Jennifer, but I'm not agreeing to anything that doesn't fully vindicate my position, and I want my attorney's fees." Frank nodded. "I understand. I'll have our attorney reach out to yours." 2 weeks later, Jennifer called me with an offer. The HOA would stipulate to judgment in my favor on all points. They'd formally declare that my van was permitted and that I could continue parking it without restriction. They'd remove all fines and the lien. They'd pay $75,000 toward my attorney's fees, which actually exceeded what I'd spent so far but would cover everything through final judgment. "What's the catch?" I asked. "No catch. They're capitulating completely. They want this over before the judge rules, probably hoping to avoid having a written decision on the record that other homeowners could use against them in future disputes. What do you think I should do? Take it. You've won. You get everything you wanted and you don't have to wait for the judge. Plus, if the judge awards less in attorney's fees than $75,000, you'd be leaving money on the table." But I hesitated. "If we take the settlement, does it prevent other homeowners from using our evidence against the HOA? Not entirely, but it would be less impactful than a written judicial decision." I thought about all the other homeowners who told me their stories. The family with the garden, the family with the basketball hoop, the disabled veteran. "Decline the settlement," I said. "Let's get the judge's ruling." Jennifer was quiet for a moment. "Are you sure? That's a risk." "I'm sure. Patricia needs to be held accountable on the record. Other people need to be able to point to a judgment that says the board was wrong, not just a settlement where they agreed to go away quietly." "You're a good man, Ryan. Okay, we wait for the ruling." Judge Mendoza's decision came down in mid-October 2024. It was 37 pages long and absolutely scathing. The judge found that the HOA had violated its own covenant procedures by failing to properly notice board meetings, failing to give me adequate opportunity to appeal, and failing to apply rules consistently. He found that the board's interpretation of the commercial vehicle provision was unreasonable and unsupported by the text. He found that Patricia had acted with actual malice based on the evidence about her son's job application. He granted everything we'd asked for. My van was explicitly permitted. All fines were voided. The lien was removed and ordered expunged from public records. The HOA was permanently enjoined from taking any action against me based on my van or home-based business. And then came the part that made headlines in the local HOA community. Judge Mendoza didn't just award me my attorney's fees to date. He found that the HOA had acted in bad faith and with malice, and therefore he ordered the HOA to pay my attorney's fees not just for past work, but for any future enforcement actions that might be necessary. If the HOA ever tried to violate the judgment, I could hire Jennifer to deal with it and send them the bill automatically. He also ordered the HOA to pay a $10,000 sanction directly to me as punishment for their bad faith conduct. The attorney's fees through judgment came to $82,000. Jennifer had kept meticulous records. The judge approved every penny, but the real killer was the future fees provision. That meant if Patricia or any future vindictive board member tried to come after me again, I had pre-approved legal protection forever, all on the HOA's dime. The judgment was filed on October 18, 2024. It became public record. Jennifer sent me the final copy with a note. Congratulations. You stood up to them and won completely. The fallout was immediate. The HOA had to send a notice to all homeowners explaining the judgment, and the resulting special assessment needed to cover the legal fees and sanction. Each household owed an additional $400 to cover the costs of Patricia's vendetta. My neighbors were surprisingly supportive. Several stopped by to congratulate me. One brought a bottle of champagne. Another brought cookies with "You win" written in frosting. But the story doesn't end there. Patricia didn't take the loss well. In early November, she showed up at my house while I was loading my van for a morning service call. I saw her coming up my driveway and pulled out my phone to record the interaction. Given our history, I wanted everything documented. "You think you're so smart," she said, her voice shaking with rage. "You've destroyed this community." "I didn't destroy anything, Patricia. You did that yourself when you decided to abuse your position as board president. My son could have been successful working for you, but you denied him that opportunity out of spite. Your son wasn't qualified for the position. That's not spite, that's business." She stepped closer, invading my space. "You're going to regret this. I'll make sure everyone knows what kind of person you really are. Step back, please. You're on my property and you're making me uncomfortable." "This isn't over," she hissed. "Actually, it is. There's a court judgment that says so. Now please leave before I call the police." She left, but not before kicking my trash can over in a childish display of anger. I reported the incident to Frank and provided him with the video. The board sent Patricia a cease and desist letter warning her to stay away from my property. 2 weeks later, something strange happened. I got a call from the Arizona Registrar of Contractors, the state agency that licenses contractors like me. They'd received a complaint about my business and were opening an investigation. The complaint alleged that I was operating without proper insurance, that I'd performed substandard work that endangered customers, and that I'd violated building codes on multiple jobs. All of these allegations were false and easily disproved, but it still required time and energy to respond. Jennifer suspected Patricia was behind it, but we couldn't prove it initially. The complaint was anonymous. However, the specific details mentioned in the complaint referenced information that only someone in my neighborhood would know, like the fact that I sometimes parked my van facing left instead of right, or that I occasionally worked on weekends. While dealing with the contractor board investigation, I also discovered that someone had left negative reviews for my business on Google, Yelp, and several other platforms. The reviews all claimed I'd done terrible work, charged excessive fees, and was rude to customers. They were all posted within a 2-day period from newly created accounts with no other review activity. This was clearly a coordinated attack to harm my business. I documented everything and had Jennifer send another letter to Patricia warning that if the harassment continued, we'd seek a restraining order and pursue additional legal action. The contractor board investigation was resolved in my favor after I provided them with copies of all my insurance policies, my spotless inspection record with the city, and testimonials from dozens of satisfied customers. The investigator told me off the record that the complaint had been obviously frivolous, and they suspected it was filed maliciously. I was able to get most of the fake reviews removed by reporting them to the platforms and providing evidence they were fraudulent. My legitimate reviews were overwhelmingly positive, so the few fake ones that remained didn't hurt my overall rating much. But the harassment didn't stop. In December, someone filed a false police report claiming that I was storing hazardous materials in my garage in violation of fire codes. The fire marshal showed up to inspect. Of course, they found nothing except properly stored tools and equipment. The marshal apologized for the inconvenience. That was when I decided enough was enough. Jennifer filed a motion to hold Patricia in contempt of court for violating the spirit of the judgment through her harassment campaign. We also sought a restraining order. The contempt hearing was in January 2025. We presented evidence of the contractor board complaint, the fake reviews, and the false fire marshal report. While we couldn't definitively prove Patricia was behind each incident, the circumstantial evidence was overwhelming. The pattern was clear, and the timing coincided with the judgment against her. We also had one piece of direct evidence. A neighbor had overheard Patricia at a holiday party in December saying that I would pay for what I'd done to her, and that she'd make sure my business failed one way or another. That neighbor, Carol Anderson, was willing to testify. Carol took the stand and described the conversation. Patricia had been drinking wine, and she was complaining about the HOA judgment. She said Ryan had humiliated her and cost everyone money with the special assessment. She said she was going to fight back by any means necessary. Did she specifically mention actions she planned to take? Jennifer asked. She mentioned filing complaints against his business license. She said she'd get him shut down if it was the last thing she did. Patricia's attorney tried to argue that venting at a party wasn't the same as actually doing something, but the judge wasn't buying it. Judge Mendoza, who heard the contempt motion since he'd issued the original judgment, was clearly annoyed. "Miss Hutchinson, I'm going to be very clear with you," he said, looking directly at Patricia. "The pattern of harassment Mr. Zimmerman has documented is extremely concerning. While I can't say with absolute certainty that you're behind every incident, the circumstantial evidence is strong, and Miss Anderson's testimony about your statements is damning. I'm issuing a restraining order requiring you to stay at least 100 yards away from Mr. Zimmerman, his home, and his business. You are not to contact him directly or indirectly, and you are not to file any complaints or reports about him or his business unless you have genuine, documented evidence of an actual violation. If you violate this order, you will be arrested. Do you understand?" Patricia nodded stiffly. "Yes, Your Honor. Additionally, I'm ordering you to pay Mr. Zimmerman's attorney's fees for bringing this motion. Miss Carlson, please submit your fee statement." That added another $8,000 to what Patricia owed. At this point, between the original judgment and the contempt motion, the total cost to the HOA exceeded $120,000 when you factored in both their attorney's fees and mine. The restraining order seemed to work. The harassment stopped. I heard through the neighborhood grapevine that Patricia's husband was furious about the legal bills and the damage to their reputation. They'd been prominent members of the community, hosting parties and serving on various committees. Now they were pariahs. Patricia stopped attending HOA meetings. She stopped participating in neighborhood events. I'd occasionally see her coming and going from her house, but she never looked in my direction. Life returned to normal. My business continued to grow. I hired a third technician in February 2025. I bought another van. My fleet of 3 matching vehicles parked in my driveway each night became a visible symbol of my victory over the HOA's overreach. The new HOA board, led by Frank, operated completely differently than Patricia's regime. They focused on actual community needs like maintaining common areas and planning social events. They enforced rules consistently and fairly. When questions arose about covenant interpretation, they erred on the side of homeowner freedom rather than restriction. In March 2025, Frank approached me about something interesting. "Ryan, the board has been discussing how to prevent what happened with Patricia from ever happening again. We want to amend the covenant to clarify the commercial vehicle provision and to add due process protections for homeowners. Would you be willing to serve on a committee to draft the amendments?" I was surprised by the request. "You want me on a committee? After everything that happened, especially because of everything that happened, you understand the issues better than anyone. And you fought for your rights when most people would have just given in. We need that perspective." I agreed to serve on the committee. Along with Frank, Susan, and 2 other homeowners, we drafted amendments that clarified the commercial vehicle rule to explicitly allow standard work vehicles under 10,000 pounds. We added a provision requiring the board to apply rules consistently or document legitimate reasons for different treatment. We added an appeals process with specific timelines and requirements. Most importantly, we added a section requiring the board to consult with an attorney before taking any enforcement action that could result in fines or liens, and requiring the board to seriously consider that legal advice rather than ignoring it. The amendments were presented to the community in April 2025. They passed with over 90% approval. The new covenant became a model for other HOAs in the region that wanted to avoid similar disasters. In May, I received a letter from Patricia's attorney. Patricia and her husband were selling their house and moving out of state. The letter included a check for $1,000 and a brief note. The note read, "Mr. Zimmerman, I am writing to apologize for my actions over the past 2 years. I let my anger and pride cloud my judgment. I abused my position as HOA president to pursue a personal vendetta against you, and in doing so, I hurt not just you but our entire community. You were within your rights to operate your business from your home, and I should have never tried to stop you. I am paying you this $1,000 from my personal funds, not HOA funds, as a gesture of genuine remorse. I hope you can forgive me, though I would understand if you cannot. I am leaving the community and moving to Colorado to start fresh. I wish you success in your business. Sincerely, Patricia Hutchinson." I stood in my driveway holding that letter for a long time. I thought about everything that had happened. The stress, the legal bills, the harassment, the 3 years of my life consumed by this ridiculous fight. Part of me was still angry. But another part of me recognized that Patricia's apology seemed genuine, and that holding on to anger would only hurt me. I decided to cash the check and consider the matter fully closed. I never responded to the letter. I didn't owe Patricia anything, not even acknowledgement of her apology. But I did let go of the anger I'd been carrying. Patricia's house sold in June 2025. A nice young couple with 2 kids moved in. They hired me to service their air conditioning system in July. I gave them a neighborhood discount. As for the lasting impact of the judgment, the pay my legal fees forever provision remained in effect. It was recorded as part of the permanent court order and ran with the HOA, meaning that no matter who served on the board in the future, they were bound by it. If anyone ever tried to come after me again for my business or my van, I had pre-approved protection. Jennifer kept a copy of the judgment framed in her office. She said it was her favorite case ever because justice had been served so completely. She still represented me for routine business matters, and knowing I had her on retainer gave me confidence. The local media had picked up the story during the trial, and it had gotten some attention. A reporter from the Arizona Republic wrote an article about HOA overreach, using my case as a prime example. That article led to some state legislators proposing reforms to HOA laws to give homeowners more protection against arbitrary enforcement. I was invited to testify before a state legislative committee in August 2025. I told my story and explained how the existing laws had ultimately protected me, but only because I had the resources to fight back. Many homeowners wouldn't have been able to afford $80,000 in legal fees, even if they knew they'd eventually be reimbursed. The committee seemed receptive, and I hoped my testimony would lead to changes that would help other homeowners in similar situations. My business, Desert Heat Solutions, was thriving beyond my expectations. The publicity from the lawsuit had actually helped. People liked supporting a small business owner who stood up to bullies. I had more work than I could handle, and I was considering hiring a 4th technician. I never moved my van. It sat in my driveway every night, right where it belonged, a quiet symbol that some fights are worth fighting and some principles are worth defending. In September 2025, I attended the HOA annual meeting. It was the first one I'd been to since before the lawsuit. Frank gave a state of the community report that highlighted improved finances now that we weren't spending money on pointless lawsuits. He mentioned that property values in the neighborhood had actually increased over the past year, disproving Patricia's claim that my business was hurting the community. During the open forum portion of the meeting, Carol Anderson stood up to speak. I want to say something. 2 years ago, I watched this board, under different leadership, go after Ryan Zimmerman for no good reason. I watched them spend our money on a vindictive legal battle they couldn't win. I watched them ignore their own rules and target one person unfairly. But I also watched Ryan stand up for himself and fight back. He didn't have to do that. He could have just moved his van and been done with it. But he fought, and in doing so, he made this community better. The new covenant amendments we passed came directly from what we learned through his lawsuit. So I want to publicly thank Ryan for having the courage to fight back against injustice, even when it cost him time and money and stress. Thank you, Ryan, people applauded. I felt my face get hot with embarrassment, but I also felt proud. Carol was right. It had been worth fighting. After the meeting, several neighbors came up to talk to me. One mentioned that he was thinking about starting a home-based business and felt confident he could do so without fear of HOA retaliation. Another said she'd been inspired by my case to push back against an unreasonable request from her own HOA in a different community. Frank pulled me aside before I left. Ryan, I want you to know that the board discussed this, and we want to formally apologize on behalf of the HOA for what happened. I know Patricia issued a personal apology, but the organization itself owes you an apology too. What happened to you should never have happened. The previous board violated your rights and wasted community resources pursuing a personal grudge. On behalf of the current board and this community, I'm sorry. I shook his hand. I appreciate that, Frank. I really do. There's one more thing, he said. The board voted to place a plaque at the community center commemorating the covenant amendments. We're calling them the Homeowner Protection Amendments, and the plaque will note that they came about as a result of your case. We want to make sure future boards remember why these protections exist. I was touched by the gesture. That's not necessary, but thank you. It is necessary. We need to remember our mistakes so we don't repeat them. The plaque was installed in October 2025. It was small and tasteful, mounted near the entrance to the community center. It read, "The Homeowner Protection Amendments to the Sunset Ridge Community Covenant were adopted in April 2025 following litigation that demonstrated the need for clear rules, consistent enforcement, and robust due process. These amendments serve as a reminder that HOA boards must exercise their authority fairly and in service to all homeowners, not personal agendas. My name wasn't on the plaque, which was fine with me. The message was what mattered." As 2025 continued, I reflected on everything that had happened since that Tuesday morning in March 2023, when Patricia first confronted me about my van. Nearly 3 years had passed, 3 years of stress and conflict and legal maneuvering. But also 3 years of growth, both personally and professionally. My business had doubled in size. I'd learned more about property law and HOA governance than I'd ever wanted to know. I'd stood up for myself in a way I'd never had to before. And I'd helped create lasting change in my community that would protect other homeowners long after I was gone. The legal fees provision in the judgment remained my favorite part. Every time I parked my van in the driveway, I knew that the HOA was forever barred from hassling me about it, and if they tried, they'd be paying my lawyer to defend me. That was justice. In November 2025, Jennifer called me with interesting news. "Ryan, I got a call from an attorney in Tucson. He's representing a homeowner in a similar situation to yours. The HOA is trying to ban his landscaping business van. He wants to know if you'd be willing to talk to his client about your experience." "Of course," I said. "I'd be happy to help." I spoke with the homeowner, a man named David Chen, and shared my story. I explained the legal theories Jennifer had used, the evidence we'd gathered, and the strategy that had worked. I also connected David with Jennifer, who agreed to consult on his case. David's case settled quickly once his HOA realized they were facing the same arguments that had destroyed Patricia's board. They backed down completely and paid his attorney's fees. David sent me a bottle of wine as thanks. That conversation led to others. Word spread in the HOA reform community that I was willing to share my experience. I helped 3 more homeowners facing similar situations over the next few months. All of their cases were resolved favorably, either through settlement or through quick victories in court. It felt good to turn my negative experience into something positive for others. I hadn't asked to become an accidental advocate for homeowner rights, but if my experience could help others avoid the same stress I'd endured, that was worth something. By December 2025, nearly 3 years after the dispute started, life had fully returned to normal. Better than normal, actually. My business was thriving, my legal rights were firmly established, my community had reformed itself, and I'd helped other people facing similar challenges. I spent Christmas with my family, grateful that the fight was over and that I'd won so completely. My brother asked me if I'd do it all again, knowing what I know now. Absolutely, I said without hesitation. Standing up for yourself is always worth it, even when it's hard. On New Year's Eve 2025, I stood in my driveway looking at my 3 vans parked in a neat row. The neighborhood was quiet except for the distant sound of fireworks as midnight approached. I thought about Patricia, wherever she was in Colorado, hopefully having found some peace. I thought about Judge Mendoza's scathing opinion. I thought about the permanent legal protection I'd won. Most of all, I thought about the principle at stake. HOAs serve an important function in maintaining communities, but they can't be allowed to abuse their power. They can't target individual homeowners for personal reasons. They can't ignore their own rules when it's convenient. And when they do those things, homeowners have to be willing to fight back. My fight was over. The judgment was final. The fees were paid. The reforms were in place. But the principle remained important, and I knew that somewhere. Another homeowner was probably facing their own Patricia, their own unreasonable HOA board, their own moment of decision about whether to comply or to fight. I hoped they'd choose to fight, because that's how things change. That's how bad actors get held accountable. That's how communities become better. The fireworks intensified as midnight struck. I raised my glass of champagne in a silent toast to homeowner rights, to good attorneys, to fair judges, and to the principle that no one should be bullied out of their own home. I took a sip and headed inside, ready for whatever 2026 would bring, secure in the knowledge that at least one HOA had learned a very expensive lesson about the consequences of overreach. And that somewhere in a filing cabinet, there was a permanent court order guaranteeing that they'd pay my legal fees forever if they ever forgot that lesson. That was justice. That was victory. And that was the end of my HOA nightmare and the beginning of something better.